Remedies. The usual remedy for breach of contract is the payment of money which compensates for injury or damages. 4 remedies include 1. Liquidated damages. 2. Damages. 3. Rescission. 4. Specific performance. 1. Liquidated damages. Contracts may be written to include some form of consequence if non-performance should occur, whether intentional or otherwise. These clauses are commonly referred to as liquid damages clauses, and may even include a set amount which will be allocated in the event of a non-performance or wrong performance. Courts uphold these stipulations as long as payment is based on a reasonable projection of damages resulting from the breach. If a court determines that the liquid damage amount goes beyond a reasonable amount and is therefore beyond the injury incurred by the breach, it will disregard the damages clause and will determine an honorable amount through its assessment of damages within the litigation process. Suppose Austin wants to purchase a duplex from Carden and he provides Carden with a good faith payment to secure his opportunity to do so. Several days pass and Austin indicates that he is no longer interested in the property. The money that Austin deposited was a liquidated damage, and as such, Carden may keep it as compensation for the exchange, and the agreement has been legally canceled. 2. Damages. Monetary penitence ordered to be paid by the breaching party does so to compensate for damages incurred by the aggrieved party. In most cases, the amount of money paid is relative to the damage incurred. An aggrieved party cannot expect to receive compensation merely to punish the breaching party for poor behavior. Punitive damages are not available in suits on contracts unless the aggrieved party was defrauded. Instead, the amount of monetary restitution paid is only intended to put the non-breach party back into the position that would have existed had the breach never taken place. 3. Rescission. Courts may order rescission when one party has breached, that is, return both parties to their original position before they entered into a contract. Contracts can also be rescinded without litigation. Returning to the example of Austin and Carden, instead of keeping the deposit provided by Austin, Carden may have the option of returning the money to Austin and rescinding the contract. This returns both Austin and Carden to their position before the contract was put in place. 4. Specific performance. Specific performance is an order of the court that requires a party to perform a specific act, usually what is stated in a contract. It is usually used to complete a previously established transaction, thus becoming an effective remedy for protecting the interest of the aggrieved party. Specific performance is often used when monetary damages would not adequately compensate for damages. For example, Julie contracted with a developer to acquire a unique piece of property on an outcrop overlooking an ocean view coastline. After the agreement was signed, the developer breached the contract by withholding title to the property. In this case, because there was no other property available in this lot, a court may determine that monetary damage would not adequately compensate for the injury incurred, and thereby order right of possession, giving Julie, the plaintiff, the right to acquire the property in dispute. Note: orders of specific performance are discretionary, as with all equitable remedies, so the availability of specific performance depends on whether it is appropriate in the circumstances of the case. Specific circumstances restrict or prohibit a specific performance order, including, but not limited to, if it would create severe hardship for the aggrieved party. The contract was amoral, criminal, or otherwise unconscionable. The claimant was at fault. The performance is impossible to carry out. The contract is too vague. The contracts had a terminable at will clause. Agreement had never been established. What you should know about loan contingency and cure. Period. Notice loan contingency. A contingency clause defines a specific event or action that must take place for a contract to become binding. The loan contingency in the contract says that if a buyer is not able to get a loan without prior to document, PTD, conditions the buyer is not obligated to complete the transaction. PTD conditions mean that loan documents will not be sent out because a lender requirement has not been met by the buyer. Let's read what the contract says about the loan contingency. Loan contingency 2B, lines 55 to 60. Buyer's obligation to complete this sale is contingent upon buyer obtaining loan approval for the loan described in the AAR Loan Status Update, LSU form, without prior to document, PTD, conditions no later than 3 days prior to the COE date. No later than 3 days prior to the COE date, buyer shall deliver to seller or escrow company notice of inability to obtain loan approval without PTD conditions. According to the loan contingency language, while the buyer is not obligated to complete the transaction if they cannot get a loan, the buyer did promise to deliver notice that they could not get a loan 3 days before the close of escrow. What happens if the buyer cannot get a loan, but breaks their promise and doesn't deliver notice of inability to get a loan? The cure period. Notice. When a party to the contract breaks a promise, and if there is no language in the contract specifying what happens next, the remedy then is to deliver a cure period notice to the non-complying party. The seller also made a promise. They made a promise to deliver a cure period notice to the buyer if the buyer did not deliver notice of their inability to get a loan. Both parties in the contract agreed, in Section 7A, lines 278, 281 cure period, to deliver a cure period notice to the non-complying party. In our example above, not only did the buyer make a promise according to the contract, but the seller also made a promise. They made a promise to deliver a cure period notice to the buyer if the buyer did not deliver notice of their inability to get a loan. Once the cure period notice is delivered, the non-complying party has 3 days to remedy their potential breach. In this case, it means that the buyer shall be entitled to a return of the earnest money if, prior to the expiration of the cure period, the buyer delivers notice of inability to obtain loan approval. Conclusion. Most of the time, when you read the word shall in the contract, a promise was made. As a rule, I recommend the use of a cure period notice when a promise is broken and the contract does not have a specific timeline as to what happens next. While the loan contingency in the contract may result in the buyer getting the earnest money, there are other things to consider in this type of earnest money dispute. Was the buyer unable to get a loan described in the PQF or LSU? What did the loan denial from the lender state as the reason for the denial? Did the buyer have the down payment or other funds necessary to obtain loan approval? Was there a diligent and good faith effort?